got your wig, ho. Ha ha. You're mad. Miss Wikiana. Miss Wikiana.
Why do you all think Karen decided to take this case to trial?
I don't know. I don't think she remembers.
Karen had terrible legal counsel. Knowing that footage was out there, who would advise that she has a public trial?
Absolutely. And maybe she didn't remember what happened that night.
But has anyone spoken to Karen?
I have.
You have?
Yeah, I spoke to her today, and things are looking good.
Okay, good.
It was postponed today.
Our actual trial date will be September 23rd, and we'll continue working on your defense before that. But that's where we are.
All right. Well, I feel much better about it. So thank you. I'm exhausted, as you can imagine.
Understood.
No sleep.
Understood.
But hey, it is what it is.
I think, though, as dots are being connected for me, I didn't watch the tapes before the trial.
No, that's such a fucking irritant. Poor wife who just let that shit go.
So I'm sitting there in the courtroom, like, I have to finally watch it. Because I kept saying, well, surely they made a mistake, right? Because everything's not connecting for me. And I watched, and I'm telling you, I didn't recognize that woman.
No,
I didn't know her.
It wasn't you.
Your driver's license for us, please?
No, you cannot.
Okay,
You ready?
Karen. Okay. Let me ask you a question. She's not free to leave. Okay?
I understand this.
Okay, so
What do
you're
you
saying...
need to know? What do you need to know, sir?
Let me answer his questions. And
No,
then
I am the person that was driving.
Okay, you were the person that was driving. I understand that, but I need your driver's license. Can you get me your driver's license, please?
No. I need to tell you something, though. Self-medicating is one thing, but I started that 7 years ago when Mom and Dad died. And so when I started taking antidepressants, it was fine. It would help. But then I needed more and more as life kept lifing.
Yeah.
And so instead of going back to the doctor, I adjusted my medication.
And my parents are dead and gone now.
I'm sorry about your dad.
Me too.
Yeah. That was...
I need a break. I knew this was going to be hard for her.
Before you beat yourself up too bad, do you know that there's 6 million car crashes every year in the United States? Wow, you had a car...
How many of them, though, Ray, self-medicate and drive? What happened to me was self-inflicted.
Okay.
I drove. I had that accident. I put people in danger.
Maybe when we were watching the footage, maybe she was watching it like us and seeing how awful she was.
That's probably the first time she saw it.
I don't know that she remembered.
No. Weeks ago was reported that her counsel asked for the footage to be suppressed.
In Touch can exclusively report. According to court documents obtained by In Touch, a Maryland judge denied Karen's motion seeking to suppress certain evidence. Back in March, Karen, 61, was involved in a car accident while driving her 2017 Maserati. She was the only person in the car when it struck a median and a street sign at an intersection before slamming into a tree. Police arrested Karen due to them believing she was intoxicated at the time of the crash. Prosecutors charged Karen with driving under the influence, negligently driving a vehicle in a careless and imprudent manner, endangering property, life and person, and various other counts. As In Touch first reported, Karen claimed after her crash she spoke to Officer Kyle Baxter and Sergeant Brett Trahan. The reality star said she was checked out by medical professionals but refused further treatment.
So it's clear that not only were they aware of the footage, they were also aware of the context because they didn't want it out.
They're trying to get rid of it.
I hope that answers your question.
That's what I'm saying.
But if you saw that...
I know. It's big delusion.
Well, we had actually seen Karen's attorney out and about a few weeks before, and he was just saying, like, oh, everything's going to be fine, just reassuring us, too. It was Giselle, Robin, and I. And so we believed him. We thought they had this in the bag, like they knew what they were doing. When that footage aired and we saw everything that transpired, we wondered how on earth did they decide to go to trial?
From what I understand, she pushed it. She didn't want to take any deal.
What?
Yeah.
Was she offered a deal?
Twice.
What kind of deal?
Yeah. I've heard 6 months house arrest.
Yeah.
I heard 60 days jail.
And she didn't take 6 months house arrest?
Ay.
I mean, I'd have taken that.
I would have taken it.
I would have I love my house.
I would bedazzle my little ankle bracelet.
Me too.
Yeah, slippers on.
Your Honor,
Mr. Martella started his presentation by referring to when the cameras are on and maybe Ms. Huger was caught on a bad day. Your Honor, this was not one bad day for Ms. Huger. This is a pattern of conduct that has been going on for roughly 20 years. She picked up her first DUI offense in 2006 here in Montgomery County. She received the probation before judgment on that. 2 years later, or I think it was 1 year later, 2007 or 2008, she picked up another DUI or DWI offense in the Eastern District of Virginia. That was pled down to a reckless driving. And then again in 2010, the DUI that she had out of the U.S. District Court here in Greenbelt. This is a pattern, Your Honor. Ms. Huger has done a lot of things, and I think that's great. She has done a lot of great programs, things that the state would have wanted her to complete. The AA, the treatment centers, the Right Turn, these are great programs that she needed to complete. However, it is striking to the state that she did not complete any of these programs until being found guilty for a third time of an impaired driving offense. I've heard nothing from the defense that she had completed any type of alcohol counseling or treatment or program after the first DUI or after the second one, and not even after she picked up these charges a year ago in March of 2024. She didn't do anything to rehabilitate herself until after the guilty verdicts came back in this case in December of 2024. Ms. Huger did go to a wellness center back in August, pre-trial, the Miraval Resort. I did look into that resort. It had 0 alcohol rehabilitation services to offer. It was quite simply a spa, a wellness center. So that's what she did pre-trial, and then it wasn't until this guilty verdict came back in December that she enrolled and got the wake-up call, I guess, to enroll in this beachside recovery. I addressed it in my sentencing memo, and I don't want to repeat myself, but the state also does have concerns that when she did choose to enroll in a treatment center, she enrolled in one that the website even touts itself on equating it to a luxury 4 or 5-star hotel experience. And I understand, as Mr. Martella indicated, when people are going through rehab, they want to be in a setting that's comfortable, and I understand that. But Ms. Huger has now, this is her 4th driving while impaired, driving under the influence offense, and it does not appear to the state that Ms. Huger has taken this seriously. Your Honor, I've seen what appears to the state as a pattern of deflection from Ms. Huger ever since this incident occurred in March of 2024. On scene, and Your Honor saw from the body-worn camera footage, on scene, she blames the accident on a car. She says she was ran off the road. That turned out not to be true. There was no evidence of that or no testimony of that. That's what she said on scene. She makes another statement about that publicly right after the accident, saying another car headed straight for her, and again, deflecting blame from the collision. And now in her sentencing memo, it seems there's more deflection of not admitting fully that she has a problem with alcohol, but rather blaming it on mixing alcohol with these antidepressants. And, Your Honor, I would like to note from the sentencing memorandum, Ms. Huger has been taking these antidepressants for, seems like decades. It's not as if, I understand the dosage may have changed, but it doesn't appear to me that this is a new prescription that she just started on right before this event and didn't know the effects. It seems as if she has been on this medication for decades and should have known better. So again, Your Honor, it just seems to be a pattern of continued deflection from Ms. Huger and a continued pattern of not fully understanding the gravity of the situation. From her prior 3 instances, she has served 0 jail time. She received the PBJ in 2007. The 2008 event was pled down to a reckless driving, which was just a payable offense, I believe. And then the 2010 DUI, she did actually serve 18 months of probation on that. I did learn that recently from the clerk from the Greenbelt District Court. But she has served 0 jail time. And quite frankly, Your Honor, it's gotten to the point when you've received your 4th driving under the influence offense, something has to give. And the state is concerned that she has been given those 3 chances. That's part of the reason we have a probation before judgment in Maryland is we understand, and the state understands, people are entitled to a second chance. But this is not Ms. Huger's second chance. This is her 4th incident. She has gotten her chance on 3 previous times and has learned nothing. I'd also like to bring up to Your Honor that shortly after our verdict in December, Ms. Huger did film a segment with her producers from the show, in which that was later released. It was just released a few weeks ago, in which she stated she's not an alcoholic, but rather, again, saying that the problem is these antidepressants with the alcohol. And I bring that up just to say, Your Honor, that I think that there is a problem with Ms. Huger, again, not taking full accountability of what is going on. If this was her first incident, I can see how maybe she would, go along that route. But when it's your 4th DUI, there is a larger problem. That, again, I just don't believe that Ms. Huger is fully appreciating. I will briefly address the issue of the 2010 DUI. We do have a printout of a docket sheet. Mr. Martella and I have tried endlessly to get any type of record from the Greenbelt District Court. I've talked on the phone with several people. I've requested it. Because of the age of the offense, they said they don't keep computer records from offenses that are that old. And of course, the physical files get destroyed after some time, and this event is 15 years old. In my supplemental supporting exhibits that I can send a courtesy copy to the court, and it was filed again on Monday, I believe, the last page of that does have this docket sheet, and I can pass this up to Your Honor if you don't have it in front of you already, where it lists the offense as DUI alcohol. I understand that on her Maryland driving record, it shows through as a driving while impaired, but it was a federal offense that she pled guilty to. From my understanding, the United States Code titles it as a DUI. The United States, the federal code does not distinguish. There is no federal DWI. I understand that maybe you can have a state DWI that's processed through federal court, but there is no federal DWI. She pled, in my understanding, to the federal offense, which is a driving under the influence. So from the state's perspective, this offense, while it did note on her driving record as driving while impaired, it is a driving under the influence event, which would cause those subsequent offender penalties to be in play for that 2-year backup time. And does Your Honor have the copy of that? I can pass up.
I have the copy of the record you gave me.
Yes, and on the last page is the docket sheet from
yes,
that.
I have that.
Okay, perfect.
I've reviewed it.
Thank you, Your Honor. Your Honor, as Your Honor is well aware, we have certain purposes of sentencing: deterrence, rehabilitation, and punishment. And I understand that Ms. Huger has made tremendous efforts to rehabilitate herself, and those are, again, things that the state would have wanted her to complete, and we are glad that she has completed them. But I do think by the time you get to your 4th DUI offense, there does need to be some level of punishment. We saw, her statements on scene of just this very entitled behavior of making statements that this is never going to touch me, and you should Google me. You're going to be ashamed of yourself when you find out who I am. And I just don't think, the state does not think at this point there has been enough accountability for Ms. Huger. She has done this on multiple occasions before, and each time she walks away with a no jail sentence and maybe some probation and some fines. And as we can see, she has done it again. So the state does believe at this point that something has got to give. She's been given the benefit of the doubt 3 times before, and nothing seems to have changed. So, Your Honor, the state's recommendation at this point would be to sentence her to the 2 years of backup time, suspend all but 6 months of active incarceration. We would ask that Your Honor place her on supervised probation. We would ask that the interlock be a condition of her probation, as well as continue in the treatment programs, the AA, understand she's already done the MAD Victim Impact Panel, which is something the state always recommends as well. But we would ask for the 6 months of executed incarceration at this time. Again, it was a collision, as Mr. Martella indicated. This is not simply driving down the road, speeding a little bit, or swerving. This was a collision where her car it started to smoke. It was inoperable. And she's extremely lucky that she did not hurt herself nor anybody else. And the state does not believe at this point that Ms. Huger has fully appreciated and taken accountability for her actions at this time. And that's the state's recommendation.
Thank you, Ms. Kramer. Ms. Huger, is there anything you'd like to say before the court imposes its sentence?
Yes, Your Honor.
All right, I'll be happy to hear from you.
I prepared a statement. Didn't want to forget anything. Your Honor, I want to apologize for taking this case to trial. But I also want to thank you for allowing me to have the trial. I think it was the mirror I needed to take a hard look at myself and the direction I was headed in. I think my prior cases, I showed up to court, followed the advice of my lawyers, got the case resolved, and went my way. I like to think I took the cases seriously. But this certainly has been such a much different experience for me. An experience that demanded that I take a look at myself, truthfully. I think for many years I was putting a Band-Aid on some personal history that was leaving me very unhappy. It is possible that just like taking daily medication for high blood pressure and cholesterol, I just thought medication for depression and anxiety was something that came with the territory of getting older and having more responsibilities and more to worry about. And certainly there was a sense of entitlement that I should be allowed to keep on consuming alcohol. I have been successful. It's been 15 years since my last DUI. Why should I give up the social indulgence? Well, this case is why. Drinking responsibly, especially while taking medications, mean not drinking at all. I failed at that miserably. I understand how lucky I am that I hit a tree. Thank God I did not hit a pedestrian. In recovery, I was told of a young man named Kevin who hit a tree when he was 17 years old. Kevin was in a coma for 30 days. Kevin is now permanently brain damaged and his life will never be the same. I asked God, why not me? The only answer I could come up with was that I was spared because I have a responsibility to use my unique optic lens and teach others and affect quite possibly millions of people with the message of not drinking and driving. I understand better the brutal clarity of the fact that when you're behind a car driving, you're not just driving for yourself. It's my responsibility to make sure my community members make it to their destination safely as well. I want to thank the officers who came to my assistance that night and apologize for my attitude back on March 19th. They were truly professional and gracious toward me at a time when I was not. The body cameras definitely prove that they were right and I was wrong. I should have handled the situation differently. Your Honor, I have a lot on my plate now, but I understand this is all for a very good reason. I will not let you down. I will not let my community down. I will follow through on everything I am currently doing to maintain my sobriety and everything you ordered me to do. And I can assure you that AA is going to remain a part of my life for the rest of my life. I will graduate out of programs, probation, and interlock terms will end. But I know that the relationships that I am creating with AA could and should and will last a lifetime. Those relationships are the greatest offer that I can offer you of my terms of sobriety and success. Thank you.
Thank you, Ms. Huger. I appreciate your comments. Karen Uger was convicted by a jury here in Montgomery County of driving under the influence of alcohol. What does it mean to be under the influence? It means that she was affected or altered by the use of alcohol. Before Ms. Uger was arrested, she refused to perform simple physical coordination tests. After she was arrested, she declined to allow the police to administer a breath test to determine the level of alcohol in her bloodstream. Both the coordination test and the breath test would have served as objective evidence as to how much the alcohol she had consumed had influenced her on March 19, 2024. However, the policeman's body-worn camera video at the crime scene provided proof positive of her inebriated state. Ms. Uger consumed so much alcohol that she drove at an exorbitant speed as she entered a quiet, sleepy Potomac neighborhood. She drove so fast and her coordination was so compromised that she flew her car onto and over a median where it sheared off a pedestrian crossing sign and spun around, slamming into a tree and landing on the grass. The impact was severe enough to crumble the front end of her Mazda and leave Miss Uger pinned behind deployed airbags in a drunken stupor. Miss Uger stumbled around the newly formed accident scene. Her eyes were wild and wandered, focusing neither on the paramedics nor the police as they endeavored to ascertain the causes of the accident and her physical condition. Despite her alcohol-induced confusion, they persisted in trying to engage Ms. Uger. Her speech was mostly unresponsive, evasive, and slurred. Her disheveled hair and clothes inexplicably never seemed to bother her. Ms. Uger demonstrated drastic mood swings. For example, one minute she was telling paramedic Han how pretty she was, and the next minute she used a crude phrase to dismiss her. She babbled incessantly as she was being driven to and while at the police station. Ms. Uger's bizarre behavior and demeanor were the result of her choice to consume excessive amounts of alcohol. The jury has found the defendant guilty of driving under the influence of alcohol, negligent driving, failure to reduce her speed, and failure to notify the Motor Vehicle Administration of her change of address in 30 days. So what is the appropriate sentence? Karen Uger is no stranger to driving drunk on our public roads. In 2007, she was found guilty of driving while impaired by alcohol here in Montgomery County. She was afforded a sentence called probation before judgment, which prevented her from receiving a license revocation or long-term suspension. This sentence for first offenders in Maryland is typical and usually comes with a requirement to attend an alcohol education program and a lecture from the judge as to what penalty would confront her should there be a reoccurrence. For most people, the uneasiness, expense, ignominy, and lecture from the court deters future drunk driving. One would think Ms. Uger learned her lesson in 2007. In 2008, before the ink had dried on Miss Uger's probation contract, she was arrested in the Commonwealth of Virginia and charged with driving under the influence of alcohol. She had an alcohol level of 0.08 or above, which is above the legal limit. Her case was plea bargained down to a reckless driving offense, for which she received no jail time. A mere 3 years later, in 2011, Ms. Uger chose to drive drunk again, selfishly putting her drinking and driving desires and habits ahead of the public's safety. This time she violated the drunk driving laws in a third jurisdiction. She was assessed a fine once again and maybe received a stern warning from the court. Karen Uger certainly had the hang of working the system by 2011. And all prior warnings had gone in one ear and out the other. Maybe getting caught for driving drunk was expensive and time-consuming, but she remained undeterred. The purposes of sentencing are: 1, adequate and justified punishment for the offense and offender. 2, protection of the community. 3, deterrence of the offender and other potential offenders. And 4, rehabilitation. So what should her sentence be for driving drunk this time? Maybe a higher fine than before? A more intense alcohol treatment program? And a lecture from me that if she commits a 5th offense, she very well could go to jail. Would a sentence along these lines really be in the best interest of the people of the state of Maryland? Would it deter anyone, including Ms. Uger, from driving drunk? Would the public be safer when traveling on our roads? The case before us today occurred on March 19th of 2024. The defendant's 4 drunk driving offenses have spanned a 17-year period. Can we believe that she's only driven while intoxicated 4 times in the last 17 years? Or is it more likely that she's been very lucky and her inebriation has gone undetected? The court will neither consider the defendant's celebrity status nor the inane statement she made both at the accident scene and while in the police car after her arrest as a basis for enhanced punishment. She was filled to the gills with alcohol. After Ms. Uger was arrested in March of 2024 on this case, she spent 6 days at the Maryvale Resort in Arizona. Not a rehabilitation or counseling center, but a luxury spa. After the jury convicted her of driving under the influence of alcohol in December of 2024, and 18 years after her first alcohol-related conviction, she sought treatment at the Beachside Recovery Center in West Palm Beach, Florida. The state correctly points out that the brochure describes the Beachside Recovery Center as a resort. She is currently enrolled in the Sun Cloud Health Outpatient Program. How about a program without a summer vacation connotation? Ms. Uger is finally addressing her substance addiction. Better late than never. Her treatment will help her rehabilitate herself if she sincerely wants help. Time will tell. What's the guarantee she's done driving while drunk? Unfortunately, there is no guarantee. Ms. Huger is a very accomplished television personality and entrepreneur. She's the mother of 2 very successful young adults. She's been involved in several impressive civic programs which have substantially aided her community. However, if while driving drunk, Karen Huger had struck a child who was in that pedestrian crossing, killing that child, does anyone think the child's parents would be consoled if told the drunk driver was a reality TV star, a good mother, and had volunteered for several community projects? Logic tells us that if we continue doing the same thing, we will keep getting the same result. We need to help Ms. Huger break this dangerous and destructive pattern and at the same time protect the public. This case demands a different outcome. The guidelines offer the court a wide sentencing range. The floor is probation and the ceiling is probation. If there was ever a time to label guidelines as ludicrous, this is the time. Would it take a 5th, 6th, or 7th alcohol-related violation before the guidelines would recommend stronger medicine than probation? I agree with the state's position based on all the documents I've been giving in the law that the maximum sentence allowed in this case is 2 years. Please stand up, Ms. Huger. The sentence on this court on count 1, driving under the influence of alcohol, is that you serve 2 years at the Maryland Department of Corrections with 1 year suspended. You will serve your 1-year time at the Montgomery County Correctional Facility. You will pay a fine of $2,000. Upon release, you'll be on probation for 5 years. After 3 years, if you have complied with all the conditions of probation, the remaining 2 years will be unsupervised. The conditions of probation are as follows. You must be supervised by parole and probation. Your probation begins upon release from jail or incarceration. Your first appointment with the supervising agent is 2 days after your release from jail or incarceration. And the address is on the sheet. You must report as directed and follow your supervising agent's lawful instructions. I have excluded 2 about work or attend school. I've excluded 3 about getting permission from your agent to change your address. So I've excluded 2 and 3. You must obey all laws. You must notify your supervising agent if you're charged with a criminal offense, including a jailable traffic offense like this. I've excluded 6, which deals with owning dangerous weapons. You must permit the agent to visit your home. 8 is really superfluous. It says you can't possess or sell or drugs or alcohol, etc. That would be a violation of obey all laws that's in there. You must appear in court when notified to do so. There are special conditions of your probation, which I'll address momentarily. Your total, we'll get to that in a minute. Special conditions are as follows. You will not be allowed to drive any motor vehicle for 1 year after your release from incarceration, regardless of what the Motor Vehicle Administration permits. That starts that year after you're released, after you serve your 1-year sentence. When you resume driving You will not drive with any alcohol in your system. Upon release, you must have an operable interlock system installed in any vehicle you drive for the duration of your probation. You will enroll and make every reasonable effort to complete any alcohol education and treatment program ordered by your probation agent. On count 2, failure to reduce speed, I sentence you to a $500 fine. On count 3, failure to notify MVA of the change of address, I fine you $100. On count 4, negligent driving, I sentence you to a $300 fine. The total fines are $2,900. That must be paid at the clerk's office. Court's cost you must pay. That's to be determined by the clerk. You'll have to pay a supervision fee of whatever it is. I think it's currently $50 per month. I didn't overlook the other things the state suggested, and maybe Mr. Martella in my conditions of probation, but I am not ordering them. Ms. Huger, you have 30 days. You have an absolute right to appeal this case. You have 30 days to note an appeal to the Appellate Court of Maryland. You have 90 days within which to ask me to reconsider my sentence. I can lower it, I can keep it the same, but I can't increase it. You have no right to a 3-judge panel because the overall sentence did not exceed 2 years. The 2 rights that you do have, the 30 days within to note an appeal, must be done within 30 days. Mr. Martella, who's as versed in the law as anyone in this county, can tell you the pros and cons of that, and same with the 90-day request to reconsider your sentence. You can take advantage of both of those rights, 2 of those rights, or 0 of those rights. It's your decision. If you ask for a reconsideration of sentence, that has to be acted upon within 5 years. All right. Is there anything that I didn't address, state or defense?
No, Your Honor. Just confirming
Pardon?
Just confirming. Obviously, there was no probation before judgment offered.
Not even close.
Okay. Just confirming for the record.
Did I ask? I didn't ask.
Yeah.
As I understand your order, she's not to drive a car for 1 year after she's released.
Correct.
And
regardless of what the Motor Vehicle Administration says.
Right. And then, is it true that then, after that year is done, then she installs the interlock?
Correct, for the remainder of her probation.
Gotcha, okay.
The probation does not start today. It starts upon release after serving the 1 year.
Right. Okay. Thank you.
All right. Everybody did a nice job. This court will stand in recess. All right.
Topic of news this hour, all lines remain in the Montgomery County Courthouse, where earlier today, Real Housewives of Potomac star Karen Huger learned her fate. Joining us now, our very own Bob Barnard outside of the courthouse with the latest. Hey, Bob, what's going on?
Hey there, Guy. Things are quieting down a little bit here. We definitely had some fans of the show who were here, Real Housewives of Potomac, and we just heard now from the attorney for Karen Huger. He said that she is accepting this 1 year jail sentence with peace, that she's had time to reflect on this. It seemed startling to almost everybody in the courtroom when the judge said, look, I know the state said sentence her to 2 years, at least it was the recommendation of the state, to sentence Karen Huger to 2 years in prison, suspending all but 6 months, so meaning 6 months in jail. The judge said no, 1 year in jail, and that when she gets out a year from now, she cannot drive her car for another year, drive any car for another year after that. And she was to be handed over to the custody of the Department of Corrections right away, leaving the courtroom and going right to jail. She did speak before the sentencing and said that she thanks God that nobody was hurt last March 19th, just before midnight, out on Oak Lawn Lane in Potomac when she had this single car accident, and admits that she has an issue mixing alcohol with prescription drugs for depression and anxiety, but that she has been going to AA meetings and plans to attend AA meetings for the rest of her life. The judge, when he handed down the sentence, said, "You still seem to think it's a problem mixing alcohol with your medications, not that you have a drinking problem." And he said, "Look, in the last 17, 18 years, this is your fourth time you've been charged, at least initially, convicted by a jury, in this case in December, of driving under the influence, and you still don't get it, even though you'd been in treatment, outpatient, inpatient, went for 31 days to West Palm Beach earlier this year after she was convicted by a jury of this DUI charge, but that you still don't take this seriously." So the judge said, "You're going to jail," and threw on these other restrictions, no driving for a year afterward. Even the folks who are fans of the show who've been watching this tell us they think it's a good sentence. They were just surprised that she got a year in jail.
Bob, do we know at what point she will actually be taken to the facility? Is it immediately, or will she have some time to actually prepare to go?
No, and you often wonder, and that varies. Often they'll say, okay, report back here in a month or 60 days. She was told she has like a 30 days or a year to appeal this sentence, but she's going right away. I mean, I had a chance to speak to John McCarthy, state's attorney for Montgomery County. It was one of his assistants who prosecuted this case and made the argument for 6 months in jail to the judge, Terrence McCann, here this morning. But McCarthy told me she's going right away to jail. So if she's not on her way, she may be being processed here at the courthouse, but will be on her way. We're told, handed over to the state of Maryland, but will serve her time more than likely, it appears, at the jail here in Montgomery County for a full year.
Bob, we know that this story is filled with plenty of drama, and when it comes to drama, perhaps no one loves it more than the Real Housewives of Potomac cast, if you will, along with the production crew. Do we know, for drama reasons, if she entered through the front door, or did she do so through the back door?
We had both doors covered, Guy, but she apparently came in through a garage, like a basement garage, with her lawyer. So she avoided the cameras going in, and we're not likely to see her going out. There may be like a jail van that'll leave here, but we won't see her. One of the arguments that her attorney, David Martella, made before the sentencing was that, had production on the latest season of Real Housewives of Potomac not been starting at about the time of her accident last March, she would have sought help sooner. That one of the reasons she didn't seek out and get help prior to her conviction in December was because of production of the show, but she avoided the cameras here today. Before the sentencing, she had told the judge that, I can use my platform, the fact that I have a camera lens, to try to advocate against drinking and driving, knowing now how bad it is from her recent re-education about it, but the judge was having none of that. And it was interesting. Some of the show watchers who were here and we spoke to afterward remarked on how the judge kind of read from a prepared statement. So yes, he listened to the arguments that Karen Huger's attorney made, that her plea for leniency, they were looking for home detention or probation, and to the state's argument, which had been spelled out in a document last week. But he kind of read from his what seemed to be prepared statement before he imposed the sentence. And one of the things he said was that, how many times does it take for someone to get caught drinking and driving before a real sentence is handed down? He blasted the guidelines that the judicial system and prosecutors were kind of limited to. And one quote that stuck out to me, he said that at the time of her accident last March 19th, she was filled to the gills with alcohol.
Wow.
So he wasn't buying that it was just the fact that she had mixed a couple of Stella beers with her medications. So pretty interesting goings on here at Circuit Court in Rockville today, Guy.
It's official. Karen Huger now to serve time behind bars. Bob Barnard joining us outside of the Montgomery County Courthouse. Thank you so much, Bob. Truly appreciate you. We'll check back with you later.
You bet.
On the show.
Before we talk about the divorce, I do want to ask you about Karen Huger.
Yes.
You both started. You are the original part of the original cast members of the show, and Karen was just sentenced to 1 year in jail for the 2024 DUI arrest. She had a 2-year sentence, 1 year in jail, 1 year was suspended. You've been friends, you've gone through ups and downs. You were there the very first season of this. I know you spoke briefly about it on the reunion show. What's your reaction?
I really do encourage everyone to keep Karen in your prayers. I really care about her. And I learned this on the train coming here today, and I cried like a baby.
I know the recent news has not been favorable, but all we can do is just continue to keep everyone in our prayers and just hope for the very best.
Think about next season and how some of the pieces are coming together. How will the season differ without Karen's physical presence on the show?
I think that, she has been someone who's been a part of the show since day one, but I think that with this group, we have found a way to navigate with her presence and without her presence. And while I definitely wish her well, looking at the reunion, I think that we maneuvered in a positive way as a collective, as a unit. So, I wish her the best, but I think that the Potomac brand still is.
Ew. Like JK, but like maybe not. But thank you for watching. But you hating ass bitches always have something to say. Hating ass bitch, but you're still watching my vids. What? You're so upset. But that's like okay, because have a piece of bread, have a Xanax, relax, because I said what I said.